Have you ever wondered what a subject to deal is? Have you ever wanted to know whether this is the right strategy for you? Have you ever wanted to know whether and to what extent you might want to use a trust when doing subject to deals? If so, you're in the right place. Stay tuned for the answers to these questions and many more. Hi, I'm William Dolan, and this is Esquire Advice, where we explain complicated and lucrative real estate and business topics. Remember, we are not forming a lawyer-client relationship by way of this channel. Always consult your local attorney before taking any action. With that said, grab a pencil and a piece of paper and get ready to learn. Welcome to our episode on Subject to Real Estate Deals. We are going to tackle this topic key concept style. But first, please kindly hit those like and subscribe buttons so we can keep bringing you valuable and profitable content. The first key concept is what a subject to deal is. This is a deal where the buyer purchases a property from the seller subject to the seller's existing mortgage on the property. In other words, the seller's mortgage is not being paid at closing and will remain as a lien on the property after closing. The second key concept is closing costs. Although a subject to deal generally allows a buyer to put up less cash to get into a deal, it does not mean you will not put up any cash. Even if you will not owe the seller any additional money, which usually you will, the buyer still needs to pay for a title search to make sure there are no liens on the property, purchase title insurance, which will cover most of the normal items except for the mortgage that's being left on the property, closing fees, recording fees for the deed, transfer taxes, and the like. So yes, generally a subject to deal should be very similar to a normal closing, except for the fact that the seller's mortgage will stay as a lien on the property. Also, the seller will have to pay transfer taxes and other applicable fees too, so you should make sure the deal is structured so there is some cash going to the seller to absorb these costs, plus put whatever cash the seller needs to receive at closing in the seller's pocket to make it worthwhile for the seller to do the deal. Title insurance and settlement agents is the third key concept. Many title insurance underwriters will not allow their settlement agents to issue a title insurance policy on a subject to deal, and some will not even allow their agents to perform subject to transactions at all because they think they pose too great a risk of causing problems down the road. Settlement agents and closing attorneys often do not want to do subject to deals even if their underwriters will allow them to do them, because they do not want to get pulled into a lawsuit or criminal investigation down the road. More on that in a few moments. Even if your settlement agent and its underwriter will allow a subject to deal, the existing mortgage will be accepted out of your title policy. Otherwise, the settlement agent should be performing a title search and giving you all of the other normal title insurance protections. I always recommend obtaining title insurance whenever it is available. Watch our video on title insurance if you're not sure why title insurance is so valuable. The fourth key concept is default. Once closing has occurred and the deed has been transferred to you, the seller's mortgage loan is technically in default because there will generally be a due on sale clause in the mortgage. If the seller's lender learns of the deed transfer, it might call the note due. Therefore, sometimes parties will try to have the seller form a trust, have the deed transferred into the trust, and change the beneficiary from the seller to the buyer behind the scenes to avoid the due on sale clause issue, and sometimes they think it's going to help them avoid transfer taxes too. The problem is that transfer tax is likely still triggered by the beneficiary transfer. The seller's title policy most likely has also been terminated, so the buyer has no title insurance coverage at all. And the beneficial interest transfer of the trust from the seller to you will not meet the safe harbor requirement of the Garn-St. Germain Act. Now you might be thinking, well, if all that's true, Bill, why do so many people talk about doing subject to deals this way? The answer is that this approach, the trust approach, creates the appearance of one transaction, but in reality is another transaction altogether. I know what you are thinking because I hear it all the time. Well, isn't that good enough? The answer is no. If something ever goes wrong, the transaction falls apart. If there's a title issue, you're stuck with the problem and no title insurance protection. If the state or local municipality or future settlement agent actually looks at what you did, you will be on the hook for all of the transfer taxes and applicable penalties and interest, whereas you would usually be splitting the transfer taxes with the seller at closing. If the lender digs below the surface and sees what you did, it will likely call the note due. See also our video on trusts and real estate transactions where we discuss land trusts and common law trusts and real estate transactions. Plus, if local law enforcement authorities begin looking into the matter, you're going to make a bad situation much worse because you essentially committed fraud in addition to the other concerns that law enforcement has, which we'll cover in a moment. Now, I've had some clients say, well, since I'm not going to pay much to purchase the property because I'm taking the property subject to, I can just walk away and cut my losses if I run into problems. That brings us to our fifth key concept, criminal liability exposure. So your seller transfers the asset, that is the property, which is the good part to you, but the seller keeps the obligation to pay the mortgage debt, which is the bad part for him or herself. Well, if you stop making payments, whether it's because you decide to cut your losses or you run into your own financial trouble, no matter what the case, the seller's credit gets destroyed. If the seller or child, sibling, realtor, friend, or anyone else hears about this, they often report it to the Attorney General's office, and there goes a criminal investigation, right? Now they're looking into whether any of your conduct constituted fraud in any way. Now, if you stand to make a lot of money, you might be willing to bear the stress, the time, and the expense of defending yourself. However, your settlement agent or closing attorney and the title insurance underwriter, who likely made a few $100s on the transaction, is not in the same position. So you can see why settlement agents and closing attorneys do not like these transactions. I know many of you are thinking, well, this is the deal that was negotiated and signed. Aren't we allowed to make whatever deal the parties agree to? Unfortunately, the answer is more complicated. First, to a non-real estate business person, these deals on the face look like a sham transaction. Believe me, I know, I have spoken to AGs about these transactions. Their attitude is usually something like, "Are you kidding me? You're telling me that this person with an 8th grade education understood when your real estate investor client who's deemed a sophisticated business person took the seller's largest asset from them for pennies on the dollar and left this poor seller with a debt he or she has no way to pay and no longer has the ability to try and sell the property to satisfy the loan? Your client left this person handcuffed to the bed and walked out of the room. Let's think about it another way. Was the seller represented by an attorney? Usually not. Therefore, did the seller really understand what he or she was doing? And I do not mean did the seller sign a bunch of disclosures that literally state, "I know what I'm doing." I've seen plenty of those. Those kind of disclosures are worthless. Did the seller understand that she now had to rely on you to make all of the mortgage payments on time for her credit not to get destroyed? Did she know that if you defaulted, she might not be able to buy a car, rent an apartment, get a credit card? Did she know that her car insurance premium might go up? Did she know she might lose a job opportunity because of it? If not, did she really understand? Probably not. Attorney generals and other law enforcement agencies are tasked with protecting consumers who cannot protect themselves from unscrupulous business practices. Look, although this is technically not true, the best way I can describe this situation, it's almost like you're guilty until proven innocent with subject to deals. So you've been warned. Now, does that mean that I have never done a subject to deal for a client? No, I have done some subject to deals, but I will not do them for a client that I don't know really well. I have to have a great deal of confidence in the client, and I have to talk to the client about that particular situation. I need to feel like there's a strong benefit to the seller in doing it, that my clients adequately disclose the risks of the transaction to the seller, and that the seller seems to understand what he or she is doing. There's a little more to my comfort level with these transactions than what I just described, but that's not really what's important here. What's important is that you walk away from this video understanding that there are substantial risks for you if you use this strategy. To me, this is not a strategy for a new real estate investor. And it's certainly not one that you want to do without an attorney or by way of a trust structure that we described above. The sixth key concept is lender communication. At some point, you will need to communicate with the lender. At a minimum, you will need to obtain a payoff statement to pay the loan if you refinance or sell the property, which presumably you will do at some point. You can get an authorization form for you to talk to the lender signed from the seller, but many lenders will not honor blanket authorizations. For example, I have seen some lenders state that the authorization must be dated and they will not accept anything older than 6 months. I have also seen some lenders require that dates of birth, social security numbers, and other personally identifiable information be included on the authorization form. These requirements can also change from time to time. So even if what you do at closing meets the lender's requirement at the time of closing, the lender could change the requirements later or sell the loan to another servicer that has different requirements. So I hope you understand that these are really tricky transactions. I also hope you've enjoyed this video on subject to real estate deals. Please kindly hit those like and subscribe buttons so we can keep bringing you valuable and profitable content. Thanks for watching, and I'll see you next time.